friend Jennings asked me on Quora, can a computer company name itself Pineapple without infringing on Apple's trademark? I'm Andrei Mincov, the founder of Trademark Factory, and here's my answer to Aaron's question. If your only goal is to prove to the world that you're going to start a computer company, name it Pineapple, that you'd be able to get away with that without Apple winning at a trademark infringement lawsuit against you, and maybe yes, you can get away with that, because maybe even Apple is going to make that argument that they own the whole idea behind calling your computer company with the name of a fruit, and whatever you're doing, no matter what fruit it is, it creates confusion. They would be able to make that argument. I think that would not fly, and the courts would find that they're trying to overextend their brand. But if you're seriously thinking of calling a computer company that, you got to be out of your mind for a few simple reasons. For a couple of simple reasons. First one is that Apple is going to drain you with lawsuits and appeals on appeals, and in the end of the day, they have virtually an unlimited budget that they can spend, and even if they're not in the right, they can still make your life absolutely miserable. So why would anyone want to start their business at a disadvantage like that? I don't know. But there's also the second reason, and that's the public. Because nobody is going to take you seriously. Everybody would understand that all you're trying to do is just to do something to spite Apple. And again, that boils down to the same question. Why would you start your business with such a massive disadvantage? If you came up with some great technology that's going to attract people's attention, don't shoot yourself in the foot. Come up with a brand that you know you can own, that you know people are going to take seriously, that you know is going to be valuable as you grow your business. Protect that brand right away, and that's how you do it. You may get some initial publicity that, oh, look at this guy, he's trying to rip off Apple and see if he can get away with that. And I'm sure there's going to be a lot of websites that are going to be advocating for you and say, no, these are not confusingly similar. And maybe that's right. But again, there is no reason to start your business at a disadvantage like that. Don't do that. All right, Mark Zmolek, I hope I'm not messing up your name, asked me on Quora, how can Realtor be trademarked? Isn't that like trademarking lawyer or doctor? It's actually a great question. When they came up with the name Realtor, it was not a word. They used to call those people real estate agents. And then somebody came up with the idea, well, let's call it Realtor. And they trademarked it right away, the association. And now they're trying to enforce it right and left to preserve the notion that Realtor is not a profession, that it's a brand. And they're having harder and harder time around this, of course, because most people, especially younger people, they have been hearing this so many times, they don't even understand that Realtor used to not be a word. Like lawyer and doctor always were words, whereas Realtor is something new. But of course, there's always a risk that at some point somebody will challenge this and claim that Realtor is just generic word, like linoleum used to be a brand, now it's generic word, or so many other ones that died by genericide. This may happen with Realtor at some point. We just don't know when. We'll see. So Rob Adams asks me on Quora, can a Madrid System trademark be transferred to a person who's not a citizen of a member nation of the Madrid System? The short answer is no. The whole idea of there being certain requirements as to who can file an international trademark application, right? None of that would be enforceable if you could have some dummy company in a member state file that trademark and then immediately transfer it over to somebody who would not be eligible for filing that trademark application on their own. And trust me, I thought of that because Trademark Factory is a Canadian company, and for many years, Canada refused to join Madrid System because there's so many big law firms here that lobby against it because they're going to lose most of their trademarking business that comes from American companies who now need to use a Canadian firm to file their trademarks in Canada. Once Canada joins Madrid, they can just file it with their American lawyers, file the international application, and designate Canada as one of the countries. Now, the interesting thing is Canada is about to join Madrid in June of 2019, though things will change. But a while ago, when I looked into how can I protect the brand Trademark Factory in many countries without spending an arm and a leg, right? That's one of the things I looked at. What if somebody were to just file that trademark on my behalf in some other country and then assign the application over to me? You cannot do that. And, that's life. That's life. You have to be eligible for filing it in the first place if you want to own it afterwards. Oh, that's a great question. Harry Lenore asked me on Quora, does common law trademark rights protect my artist name if I'm selling music globally on iTunes or so? You gotta realize that common law rights or common law trademark rights exist only in a handful of countries. Most countries, the vast majority of countries out there, do not recognize unregistered trademarks. So if you haven't trademarked your brand there, like in Europe or in most Asian countries, or like I said, most countries on this planet, if you haven't filed your trademark there, you have zero trademark rights. So you may be known worldwide as an artist, you have very few trademark rights until you actually take steps to trademark your brand. And yes, you may get away with that, let's say in the US, in Canada, UK, Australia, maybe, Israel, a few other countries. But you really should not rely on this if you're trying to build a global brand, a global presence. All right, Roy Hobbs asked me on Quora, do you think that the placement of the TM symbol next to a logo diverts customers' attention away from the logo? Well, obviously it depends on how you place the TM, how prominent it is, but generally I don't think that people really care all that much unless they're trademark attorneys or trademark agents or trademark professionals like me, who it's probably the first thing we notice, right? Is there a TM? Is there an R in a circle? If there's neither, how can they notify the world that it's a registered or unregistered trademark, stuff like that. But I think normal people, it's really not a concern. They glance over it. And I know this whole debate, should we use it, should we not use it? And I find that today some companies almost feel ashamed that they own property around their brand. And that's another reason why they remove the notices, whether it's TM or an R in a circle. But really, there's no reason to build a brand unless you plan to own it. And there's no reason not to tell the world that you've actually accomplished something, that you've built something, and that it's yours. So I think it could be a design issue one way or the other to make sure that you still have that notice without it diverting the customer's attention away from the actual logo. But I think that these thoughts, these concerns should not make you remove those notices, because I think you'd be losing a valuable part of the message that you can convey to the world by adding a TM or an arm. All right, Barron Branson asked me on Quora, am I allowed to use a trademarked word within my domain address, such as Shopify? It really depends, and I hate saying this, but it really depends on a couple of things. One, it depends on what the word is, how common it is outside of the brand that it's trademarked for. Like Apple, right? If you're selling apples, nothing prevents you from using the word Apple in the domain name Apple. And the other thing to look at is what your activity is. Are you trying to create the perception that you're somehow associated with, licensed by, or endorsed by that other brand? And if you do such a thing, then the brand owner would probably have a pretty good case against you not being allowed to put their name in your domain name. But if what you're doing has nothing to do with what they do, then it should be okay, right? Again, two things: how uncommon their word is, and two, are you trying to convince the world that you're somehow associated with them? Now, to the specific question of Shopify, if Shopify is the word, then it could be an issue because it's an invented word that they came up with, that they trademarked. And so if they feel that whatever you're doing, your domain name or your activity behind the domain name somehow threatens the integrity of their brand, they'll probably go after you and they're probably going to be able to win. But the rule of thumb here is, if you're not sure, don't do that, because it's a lot easier to build a brand from scratch that doesn't rely on you getting away with what might be perceived as an infringement, versus you just starting out with a name that's new, that's unique, that you can build some massive value on and claim it as your own. This is what Shopify did. They didn't call themselves Amazonify or Walmartify or something else. They came up with their own name and they made that into a name that everyone finds very valuable. All right, David Kennedy asked me on Quora, what's the difference between trademark and copyright? I mean, there's a lot of things that are different between a trademark and copyright, but in a nutshell, copyright is designed to protect content as such. Your books, your videos, your music, your software, your posts, whatever it is, it's something you create that's protected for the value of the content itself. Versus a trademark, the trademark has a completely different function. The function of a trademark is to help people tell your products and services apart from identical or similar products of everyone else, right? So the swoosh, the Nike swoosh, is not protected as a trademark because it's an amazing piece of art. It's protected because it identifies Nike. So that's really the difference. But the swoosh itself actually is protected both by copyright as content, as the image, and as a logo, as something that's capable of creating that mental link between the image and their products and services. So really that's the difference. Logos are typically the only time there's an overlap between copyright and trademarks. Other than that, if you're thinking that you're protecting content, that's copyright. If you're protecting identity or branding, that's trademarks. Now, David, I hope this answers your question. And if that's the first time you're seeing my videos on trademarks, and if you found this one interesting or useful, subscribe now, get notified whenever the next one goes live, and I'll see you in the next video.